There must be mutual consent of the parties. What do you mean by this? What comes to your mind?
Agreed by the people involved in the contract.
Yes.
Agreement of the people involved in the contract.
Okay. All right. Agreement. Yes. So mutual consent of the parties means that both the parties are agreeing to the same thing in the same sense. That is called mutual consent. Okay, sorry. So mutual consent means both the parties, party A and party B, are agreeing upon the same thing in the same sense. You are wanting to sell a cell phone. You have two cell phones, and actually you have white and green color cell phones. All right, you have two cell phones, white and green. You have an intention to sell the white one, but the person who is going to buy is actually targeting the green one. And so, if that is the case, both are agreeing to buy, and one is agreeing to buy, the other is agreeing to sell, but it is not agreeing on the same thing. It is not agreeing on the same thing. One is targeting the white, the other is expecting the green. Correct or not? Am I clear?
Yes.
Yes,
Yeah.
sir.
So these two
Yes,
persons,
sir.
these two persons are not having a common meeting ground. They are understanding two things in. They are understanding in their own sense. They are able to interpret in their own way. One is talking about the white, and another one is agreeing on the green. So there is no meeting point. There is no meeting point, and therefore that will not be valid. That will not lead to a valid contract, and therefore the terms of the contract should be such that both the parties are agreeing on the same thing in the same sense. Number three, there must be legal obligations. All right. So what is an obligation? Obligation is what? An act to do or not to do. Legal obligation. Something that is legal. If a contract is to be made, then there should be legal obligation. The purpose of entering into an agreement should be for something that is permitted, for something that is allowed by the law. It should not be on something or on some moral grounds. Let me tell you straight. It should not be on, an agreement should not be on some moral grounds or on social obligations. Agreement should not be on that. There could be an agreement, but that agreement cannot be called a contract if it is on some moral or social obligations. I will pay you 50 rupees if you clean the house, if you cook for me, if you attend classes. These could be agreements, but they are not contracts. Do you get me? Do you get me? Yes or no?
Yes, yes, sir.
There is an agreement in that, but they are social contracts. If one, after giving 50 rupees, if the person does not sweep or clean the house, we cannot take the person to the court of law and tell, hey, this person have to pay back because I paid 50 rupees, but he or she did not clean the house. No, the law cannot enforce that because that is a social obligation. That is a social obligation. All right. So also moral. Okay, I'll pay you 10 lakhs. Go and kill that fellow. Go and terminate this person, this man. All right. Such types of contracts are there, but they are not contracts. They are agreements, but they are not contracts. All right. It cannot be enforced in a court of law because it is immoral. It is something immoral. It is not permitted by the law. So there must be legal obligation means to do something that is permitted by the law, to carry out, to enter into a business. Okay, I will bring these goods for you. You will pay me this much amount with discount, with this one, with that one. That is legal. That is enforceable in the court of law. Can we proceed? Can we proceed, class?
Yes, sir.
Yeah. In case you are feeling boring, please let me know, okay? Okay, sorry. Number 4, there must be free consent of the parties. Okay, that is repeated. There is, okay, so come to 5th one. There must be free, all right, okay, 4, that is correct. There must be free consent of the parties. So the second, I got confused with the second point. So the 4th point says there must be free consent of the parties. What do you mean by this? Free consent of the parties. Free consent of the parties means?
Mean, means no one should force for an agreement.
Okay, very good. That means there should not be anybody forcing a person to enter into a contract. There shouldn't be force, there should not be coercion, there should not be undue influence. All right? Am I clear? The
Yes, sir.
person who is entering into contract should be entering with his or her free willingness. Nobody should be threatening him or her. Nobody should be forcing. Nobody should be influencing. Hey, you have to enter. Of course, in reality, there are so many forced agreements and forced contracts signed. If you don't sign this paper, that you will enter into business with this group, then I'm going to kill you. I'm going to blackmail you. Oh, all those are there. All those are there. But they are not termed as contracts. Because they are illegal. It is with force, threats and force and undue influence. Those are not permitted. If such elements are there in the formation of contract, they will become what is known as invalid contracts. They will be called invalid contracts. Can I proceed? Is that okay?
Yes, sir.
Yes, sir.
No responses. No responses. We have to participate in my paper. Then, number 5, the parties must be competent to contract. Okay. The parties entering into contract must be competent to contract. What do you mean by this? Competent means who is the competent party or person to contract? What do you think? Complete silence. Now my question
Yes,
is,
sir.
okay, are you competent enough to enter into contract? Are
Means,
you
sir, having the
all?
knowledge,
Yeah.
information or knowledge about the contract. Information or knowledge about the contract. Having a person information or knowledge.
Oh, okay. You said good for the trial. Yes. So now, in detail, we will talk about this, but straight away, let me make a mention of some of the few categories that are not eligible to enter into contract. And those who fall under these are known as the incompetent parties to contract. All the rest, the incompetent parties minus the rest are all able to enter into a contract. So, who are the incompetent parties to contract? Let us first know that. Number 1, listen carefully. Number 1, minors. minor. A minor. Who are minors? Who are minors? Who are minors? Or who is a minor? Somebody please try. Who is a minor? Yes? Okay.
Head of the
Then,
business.
yeah? Yes? Somebody making an attempt? Oh, okay.
Minor is
Oh, all right.
under a
Good,
certain.
Sabir. Yeah, good, Sabir. Please continue.
Yeah.
A minor is a
Sir,
person under a certain age, usually the age of majority, which legally demarcates childhood from adulthood.
Okay. So what is the exact age? What is the exact age?
18.
Teenagers.
Yeah?
18.
Okay, good. All right. After a long research, managed to get the right answer. Very
Okay,
good.
just kidding.
Okay, so a person below 18 years of age is a minor, all right? So a minor cannot enter into a contract. A minor is considered as a person who is still immature in the eyes of law, and therefore a minor cannot enter into a contract. That is the first incompetent party. Number two, a person of unsound mind, a person who is derailed of his or her mental faculty of thinking, not able to think clearly, reason clearly, or not being rational enough. The thinking capacity, rationality could be affected because of so many reasons, could be because of use of substances, alcohol, drugs, or could be because of the mental trauma, all right? Lunatics, idiots, drunken persons, etc. falls under these persons of unsound mind, all right? So persons of unsound mind cannot enter into a contract. Then the third category is persons who are disqualified by law, all right? Disqualified by law. Disqualified by law people are those who are serving jail terms, all right? Criminals, or who are still having jail sentences, all right, are falling under this category. So all these people cannot enter into a contract. The rest can be permitted to enter into contract. Is that okay? Any question? Any question from anybody?
No, sir.
hello.
Yeah.
No, sir.
Okay, good. Then let us proceed on to the next. There must be a lawful consideration. Lawful consideration. What is a consideration? Consideration is an act to do or not to do, and to abstain from doing it. That is a lawful consideration. Supposing I say, all right, if you supply me X, I will pay you this much amount for the traveling expenses, this much for your commission, I'll pay you this much, and for the cost of the act, I will pay you this much. That is money consideration. That is money consideration, and that is lawful consideration. So in a contract, there is going to be a give and take. One is going to give, the other is going to take for the service rendered. Correct? So lawful consideration is an act in return for the service rendered or for the goods supplied should be lawful. It should be lawful. What do you say? Yeah, any doubt? Can I proceed? Yes or no? No response. No response.
Yes, sir.
Yeah, yeah. I need your feedbacks from time to time. Okay, then moving on to the next. There must be lawful object. What is an object? Object, the purpose for which the contract is made, is going to be made, is known as the object. What is the purpose for entering into a contract? If somebody call you and asks you, hey, shall we do a business? Shall we enter into a contract? Then your next question will be, for what? What kind of business? For what purpose? Isn't it? That will surely come to your mind. And so, what is the purpose of entering into a contract? What is the objective for entering into a contract? That has to be understood. And that should be something lawful. That is not forbidden by the law. That is not against public interest. That is not against the public welfare, against the general public welfare. So the object should be to create something, to do something lawful, all right, by selling, transporting, rendering services in turn for payments. All those can be considered as lawful objects. Then the agreement must not be declared void. Void. The agreement must not be declared void. What do you mean by void? Void, something not acceptable in the eye of the law. Void, isn't it? Useless, not acceptable in the eye of the law. That is not lawful, is called void. All right. So the agreement must not be declared void. Now, let me give you an example. Human trafficking is not allowed. That is not allowed. It is against the law, isn't it? It is against the interests of the public. And therefore, anybody entering into contracts to do human trafficking, all right, which we are seeing every day, lots of people from the northeast regions are lured with employment opportunities outside, and once they reach there, they are made to do manual labor jobs. They are exploited for different purposes. And all these people who are doing these businesses are entering into agreements which are declared void, punishable by law, and therefore once they are caught, they are sent behind bars. They are put behind bars. Is that okay? So the agreement must not be declared void. Therefore, when the agreement is in the beginning, when contracts are made, it could be valid. It could be something acceptable. But later on, you know, the law can change. The law can be changed from time to time. Government keep on changing the laws. Correct or not? Different governments of the day keep on changing different rules, different regulations. For instance, Nagaland is a dry state. So anybody doing liquor business is punishable. Now, after 1-2 years, a new government steps in and then they declare, oh, no more. Nagaland shall be called a wet state, which means doing alcoholic business is no more an illegal business. That is permitted. It is equal to, it is like any other business selling clothes or other stationery items, food items, etc., etc. Am I clear? What do you say?
Yes, sir. Yes, sir.
Yeah. Okay,
Yes,
so
sir.
the agreement must not be declared to be void. So that can be done at any stage. All right. Number 9, just I have few more minutes. All right, let me finish up this. The agreement must be certain. All right. So if an agreement is entered, and if that agreement is called a contract, then there must be certainty. There must be certainty. And when we talk about certainty, we are talking about the time. The contract should not be going on indefinitely. There should be a specific time. All right, this business or this agreement will last for 2 days, 1 week, 2 weeks, 1 month, or 6 months. Within that, we have to finish up the contract or go for another 2 years, etc. But certainty of time must be there in a contract. A contract should not be having an indefinite time period for its execution. Certain specific timing should be there, then only we call it as a contract. The last one, number 10, the performance must not be impossible. All right, so agreements entered where the fulfillment is on some impossible objects or on some impossible clauses, then that cannot be termed as a valid contract. The term impossibility differs from place to place, from person to person. Now, if I say, I will go to Bangalore and come back in 3 minutes. It is possible for me to go to Bangalore, but not in 3 minutes. Not in 3 minutes. It is just impossible. And therefore, if I say, okay, you stay on, I will go there and come within 3 minutes, all right? And if I do that, how much you will pay me? I'll pay you 10 lakh rupees if you can do that. All right. Within 5 minutes, I will bring this for you from there. Impossibility elements are also there in contract. And so if impossibility elements are there in any kind of agreement, then those agreements will be outside the jurisdiction of the law of contract. So those are the very essential elements of a contract. And these 10 items, 10 elements are the bedrock for all types of businesses. It is not applied only in contracts, buying and selling, but also in all other types of businesses. If you look into them, then they are to be read into all types of businesses. So that much is what we have for today. So before I wrap up, I will make a brief highlight of all what we have done today. So we had a brief recap of what we have done yesterday. I have thrown on you certain questions. All right, it was forthrightly answered by you. Then we started talking about contracts. All right, section 2, clause H defines contract. Then we talked about agreement. Then the valid the legal definition of agreement is seen in section 2, clause E. Then went on to discuss what is a promise, seen under section 2, clause B. Then straight away we got our foot into the essentials and legal rules for a valid contract. We have seen 10 of them, very essential, very important, very simple terms. All right. So these are what we have done today. The rest of it we will follow up in the next week. Till then, take care, and then please make sure during the class you are also having a pen and a sheet of paper, at least to take down the points and be pondering on them. All right, it is very important to be taking active part. That is very important. So I hope to see you with a pen and a sheet of paper in the next class, at least to jot down some of the important points, because what we hear we will forget, and we are bound to forget it. So in order not to be too strange with what we have at least done, let us at least note down some few points and keep it with us as a sign that we are serious and that we are learning. All right. So once again, thank you so much, everyone. And then before you sign out, I want to take the attendance. So please stay on the screen. Yeah. Okay then. Thank you so much, class, for your keen participation. Good day. Thank you. Yeah.
Yes, sir.
Oh, yeah. Okay. Thank you so much. See you tomorrow. Next week. Yes.
Okay, okay, sure.
Yeah.
Mhm.